They handed me a glass of wine and called me the farmer. For 11 months, I let them believe it. I wore my old flannel to their dinners. I said shucks and I reckon, and let Gerald Whitfield explain hedge funds to me like I had never touched a $100 bill in my life. I let his wife Marlene look at my calloused hands like she was cataloging evidence of a lesser man. What none of them knew, not Gerald, not Marlene, not even my own daughter, God rest what she went through before this ended, was that for 22 years, I sat on the federal bench. I sentenced men exactly like Gerald Whitfield, men who smiled while they stole, men who dressed their greed up as generosity. And the night I stood on a stone terrace in Connecticut and heard him whisper 4 words to his lawyer, restructure before the wedding, I stopped being a farmer. I became a judge again. By the time I was finished, Gerald Whitfield didn't have a family left to protect. He didn't have a company. He barely had a name people would say out loud in that town anymore. If you've ever been underestimated by someone who thought your quiet meant weak, stay with me. Because this story is for you. Here is exactly how it happened from the beginning. My name is Richard Callahan. Everyone who matters calls me Rick. I'm 68 years old. I live on 41 acres just outside a small town in Ohio, in a farmhouse my late wife Susan and I bought the year after I retired, and until 3 years ago, almost nobody outside a federal courthouse knew what I used to do for a living. I spent 22 years as a United States federal judge, appointed at 41, one of the youngest in the circuit at the time, confirmed after a Senate process that took 11 months and more sleepless nights than I care to remember. I sat on cases involving racketeering, wire fraud, and more trust and estate litigation than any one man should have to witness. I watched families, good families, families that once loved each other, burn themselves down to ash, fighting over inheritances that were never really about the money. They were about who felt owed something, about who felt cheated by life, and decided a relative's bank account was the fastest way to feel whole again. I saw that pattern so many times that by my 15th year on the bench, I could smell it in a courtroom before the first witness even took the stand. I retired the year Susan got sick, stage 4, and by the time we caught it, the doctors used careful words like manage instead of cure. I did not want to spend her final chapter sentencing strangers while my wife faced the only sentence that mattered. I stepped down within 3 months of her diagnosis. We bought the farm that spring. Her idea, actually. She wanted somewhere quiet, somewhere with dirt under her fingernails again, like the Kansas childhood she never stopped missing. Susan passed 18 months later, on a Tuesday in March, in the bedroom of that farmhouse, with the windows open because she wanted to hear the birds. I did not go back to the bench. I could not imagine wearing that robe without her waiting for me at home. So I stayed. I grew tomatoes because she used to love them fresh off the vine, still warm from the sun. I fixed fences because it gave my hands something honest to do while my mind grieved. Nobody in town called me Your Honor anymore. Frankly, I liked it that way. There is a kind of peace in being underestimated when the world has already taken the thing you valued most. My daughter Emily was 26 when her mother died. She is my only child, and in the months after Susan passed, Emily became the sole reason I dragged myself out of bed some mornings. She flew in from Chicago every other weekend that first year, sat with me on the porch, cried with me, made me eat actual meals instead of black coffee and guilt. Susan, in her final months, insisted we set up a trust for Emily, not a small gesture, but a real one. $2.3 million, drawn from Susan's family inheritance and our combined life savings, placed into an irrevocable trust with staged distributions, fully accessible when Emily turned 35, with narrow, court-documented exceptions before that age: medical emergency, home purchase, education, nothing else. I wrote half those provisions myself, sitting in a plastic hospital chair beside Susan's bed, both of us determined that our daughter would never, not once in her life, be at the financial mercy of another human being. I know that document like scripture. I have read it more times than I have read my own wedding vows. 2 years ago, Emily met a young man named Daniel Whitfield at a finance conference in Chicago. She called me that same night, practically breathless. "Dad, I met someone. I don't know, he's different. He listens." He asked me actual questions about my work instead of talking about himself the whole time. I remember smiling at that. Susan would have loved hearing her daughter's voice sound like that again. Daniel was, by every visible measure, a good man. Harvard-educated, worked in wealth management in Manhattan, the kind of young man who pulled out chairs, remembered birthdays, called his own mother every Sunday without being asked. I met him for the first time that Christmas, and I liked him. I want to be honest about that, because not everyone in this story deserves what eventually happened to them. What I did not know yet, what I would not learn for almost a full year, was exactly who had raised him, and exactly what kind of family he came from. The first time I met Gerald and Marlene Whitfield in person was at a dinner Emily arranged in Manhattan, roughly 6 months into her relationship with Daniel. They flew up from their estate in Greenwich, Connecticut, in a car that likely cost more than my entire farmhouse. Gerald shook my hand the way certain men shake hands when they've already decided, before you've said a single word, that you do not matter to them. Firm, brief, his eyes were already moving past my shoulder, scanning the restaurant for someone more useful to look at. Marlene studied me the way an appraiser studies a piece of furniture she suspects is a knockoff. My boots, my hands, still calloused from fence posts and tomato steaks, my off-the-rack suit that I'd bought for Susan's funeral and worn maybe 4 times since. "So you're a farmer?" Daniel mentioned. "That's how many acres exactly?" Dialogue. Rick, plain, unbothered, 41, mostly tomatoes and corn. A little hay for a neighbor's horses. I watched something in Gerald's shoulders relax. Whatever quiet threat a protective father might represent, tomato farmer with 40 acres clearly did not register on his radar. Marlene offered a smile that never once reached her eyes. "That's wonderful, real honest work. My grandmother's family had a place upstate actually, very rustic. I always found it charming in its own way." I smiled back. I let it happen. 22 years on the federal bench teaches a man something extraordinarily useful. When people underestimate you, they stop performing. They show you, without meaning to, exactly who they are underneath the good tailoring. Over the following year, I watched the Whitfields the way I used to watch witnesses on cross-examination, not obviously, never confrontationally, just quietly, patiently, cataloging small inconsistencies. Gerald ran a private equity operation called Whitfield Capital Partners, founded by his own father back in the 80s, now technically run by Gerald as managing partner. From small comments Daniel let slip over the months, not out of disloyalty, just the careless way young men talk when they don't realize what they're revealing, I learned the firm had launched 2 new funds in the past 3 years, both underperforming badly. There had been an investor lawsuit at some point, settled quietly, sealed, the kind of thing that never makes headlines, because enough lawyers get paid to make sure it doesn't. Marlene ran something called Whitfield Signature Events, a boutique event planning company that, as far as I could ever tell in 18 months of paying attention, mostly existed to stage the appearance of wealth the family no longer comfortably possessed. Charity galas, garden parties, a carefully curated Instagram presence that looked, to any outside eye, like old money aging gracefully. They were drowning, both of them, quietly, expensively, and they were smiling the entire way down. I said nothing. Emily was in love, genuinely, and I was not about to poison that on a hunch and a bad feeling about hand gestures at dinner parties. Daniel, to his credit, seemed to adore her without any visible agenda. So I watched, and I waited. Old instincts, I have found, do not retire simply because the man wearing them does. Daniel proposed on a Saturday in October, at the small pond on my property, where Emily used to catch frogs as a girl, her knees always muddy, her mother always laughing at her from the porch. Emily called me that night in tears, the good kind, the kind that make a father's chest ache with pride and grief in equal measure, because Susan should have been there to hear it. I drove out with a bottle of decent bourbon that same night, and for one clean, uncomplicated evening, I let myself simply be a proud father. No suspicion, no old instincts, just joy. That clarity lasted almost exactly 3 weeks. It was a phone call from Emily that first cracked it open. Nothing dramatic, just a passing comment, the kind of thing a daughter mentions to her father without realizing its weight. Oh, and Marlene mentioned something about a prenup. She said it's just standard practice for families like theirs, and that their family lawyer would draft something simple and fair before the wedding. Daniel says it's really no big deal. Narrator, I kept my voice light. I asked a few gentle questions. What kind of language, what firm, what timeline, and got vague answers. The kind a young woman gives when she genuinely isn't paying close attention because she trusts everyone involved. That night, alone on my porch with a cup of coffee gone cold in my hand, something old and familiar stirred in me, a feeling I hadn't had since my last year on the bench, the feeling of a case forming before I'd even seen the first piece of real evidence. I told myself it was nothing. Prenups are common. Wealthy families protect assets. That alone is not a crime, and it is not, by itself, a betrayal. But 22 years of reading people does not simply switch off because a man traded his robe for a flannel shirt. And something about the phrase, standard practice for families like theirs, sat wrong in my stomach for the rest of that week. The engagement party was scheduled for 6 weeks later. Marlene insisted on hosting it herself at a country club outside Greenwich, and insisted, gently but firmly, that it be a proper affair, the way these things are traditionally done. I said very little. I simply started paying closer attention than I had in over a year. The party was, unmistakably, Marlene's production from the first note of the string quartet to the last drop of the signature cocktail named, unbearably, the Whitfield Sunset. 200 guests. An ice sculpture of the couple's entwined initials slowly weeping onto white linen. Waiters gliding between old money faces I did not recognize and did not need to. I wore my one good suit, the funeral suit, and played my part well. Quiet, polite, a little out of place among the crystal and the caterers, exactly as they expected. Gerald introduced me to a rotation of his business partners the same way each time. This is Emily's father, Rick. He's got a little farm out in Ohio. Salt of the earth, this one. Every single time I watched people's eyes slide past me like I wasn't worth remembering, exactly as they had learned to do from Gerald's tone. That was precisely what I needed them to keep believing. I want to describe one particular exchange in detail because it matters for what comes later. Roughly an hour into the party, I found myself standing near the bar beside a man I did not recognize. Mid-50s, expensive but understated suit. The specific posture of someone accustomed to rooms full of important people. You must be the father of the bride. Gerald mentioned you have some land out west. Ohio, actually. Not quite the west. 40 acres. Tomatoes mostly. How charming. I'm sure that's very grounding. I later learned that man was Charles Weatherby, senior partner at a white shoe law firm in Manhattan, the very lawyer, as it turned out, who would draft the language I'd find myself dissecting 3 weeks later. Around 10 o'clock that night, needing air away from the noise and the perfume and the performance of it all, I stepped out onto the terrace overlooking the golf course. Stone balustrade, string lights, the particular hush of very expensive quiet. That is when I heard them. Gerald and Charles Weatherby, standing just around the corner of the building, close together, voices pitched low, in the specific register people use when they have already decided no one is listening. The restructuring needs to happen before the wedding, Gerald. Once they're legally married, commingled asset language becomes significantly easier to justify if anyone ever looks closely. You said the trust converts into a marital asset discussion the moment there's a joint filing on record. It will. I've already had you draft the language into the prenup itself. Daniel doesn't need to understand the mechanics. He just needs to sign what's put in front of him, the way he always does. The trust becomes accessible as collateral within 18 months of the marriage under the family hardship clause. That buys us the runway we need to cover the fund shortfall before this SEC inquiry closes in on us. And if the inquiry moves faster than 18 months, then we accelerate the timeline, push the wedding up. I don't care how it looks, Charles. I care about not losing everything I have left. I stood absolutely, perfectly still against that stone balustrade, a glass of wine slowly warming in my hand. 22 years of listening to men lie to juries had taught me one thing above all else. I have never, not once in my career, needed anyone to repeat themselves for me to understand precisely what I was hearing. Gerald Whitfield was engineering his own son's wedding and my daughter's trust fund as the collateral mechanism to bail himself out of what sounded very much like an active federal securities investigation. He was not simply marrying his son into money. He was preparing to launder his own professional collapse through my daughter's inheritance, through the last gift her mother ever gave her. I walked back inside. I found Marlene near the dessert table, complimented her flowers, said something forgettable about the string quartet's arrangement of an old standard. My voice did not shake, my hands did not shake, but something in me, something that had been quiet for 3 years, had just fully, unmistakably woken back up. Nobody in that room had any idea what had just changed. I did not confront anyone that night. I have watched too many careers, too many prosecutions, collapse because someone moved on emotion before they had built an airtight foundation. Emotion wins arguments at dinner tables. Evidence wins everything else. I drove home to Ohio the next morning and, before I even unpacked, made the first of what would become nearly a dozen careful, quiet phone calls. The first call was to a man named Thomas Reyes, my former clerk from my second decade on the bench, now a partner at a securities law firm in Washington, D.C. We had not spoken in almost 2 years, but some relationships do not need maintenance to remain solid. Judge Callahan, it's been a long time. What can I do for you? Off the record, Tom. Does the name Whitfield Capital Partners mean anything to you? Yeah, actually, there's chatter around the office, nothing public yet. The SEC's Enforcement Division has an open, active inquiry. Investor complaints about materially misrepresented fund performance, going back at least 3 years, maybe longer. It hasn't been announced because they're still building toward a formal action. Why do you ask? I told him only what he needed to know for now, that it might become personally relevant, and that I would call again soon. The second call was to Patricia Nguyen, a forensic accountant I had relied on in a dozen complex fraud cases over the years, a woman whose attention to detail bordered on the supernatural. I asked her, on a modest personal retainer, to quietly compile whatever public filings, court records, and financial disclosures existed on Whitfield Capital Partners. The third call was the hardest one I made in that entire ordeal. I called my daughter. Dad, I was just thinking about you. Wasn't the party incredible? Marlene really outdid herself. It was something, sweetheart. I need to ask you something important, and I need you to really trust me on this. Has anyone, Marlene, Gerald, Daniel, mention specifics about that prenuptial agreement? Or anything at all about your trust fund? Just what I told you before. Marlene said, it's standard for families like theirs, and their lawyer, Charles somebody, is drafting it. Daniel said he'd sign whatever his dad's lawyer put together. He trusts his father completely with that stuff. Dad, you're scaring me a little. What's going on? I told her, as calmly as I could manage, that I needed a few weeks. I told her not to sign anything at all, not even a coffee receipt with Gerald Whitfield's name on it, until I called her back personally. My daughter has trusted me completely since the day her mother died, and that morning, sitting alone at my kitchen table with the phone still warm in my hand, I was more grateful for that trust than I had been in years. Over the following 3 weeks, I stopped being a retired farmer in any meaningful sense and became, quietly, methodically, exactly what I used to be. Patricia's research confirmed and then exceeded what I had suspected. Whitfield Capital Partners had reported investor returns across 2 of its funds that did not match the actual filed performance data, a discrepancy she calculated conservatively at just under $11 million. The SEC inquiry Thomas had mentioned was not theoretical or distant. Internal filings suggested formal enforcement action was likely within 3 to 5 months. Gerald was not being paranoid in that terrace conversation. He was a man watching the walls close in real time, doing the math on how much longer he had before everything he had built and stolen to maintain came apart in public. His plan, once Patricia and I laid every piece side by side, was elegant in exactly the way true fraud always is: simple on the surface, devastating underneath. Rush the wedding timeline. Ensure the prenup, drafted entirely by his own family's lawyer, presented to Daniel and Emily as routine, unremarkable paperwork, contained language reclassifying Emily's trust as accessible marital collateral in the event of family financial hardship. Once married, Gerald could quietly draw against that provision or pressure his own son into co-signing a loan secured by it, all before the SEC's public action froze his personal and business assets entirely. If it worked, my daughter's inheritance, the very last gift her mother built for her from a hospital bed, would become the emergency fund for a man who had never once, in 18 months, asked whether that was acceptable. I need to be honest about something here, because this story only means something if I am. I was not simply a retired judge, coldly analyzing a fraud pattern anymore. I was a father. I was a widower, defending the last physical evidence of his wife's love for their daughter. Those 2 things, the judge and the father, became, for the first time in my life, exactly the same person. I requested a full copy of the draft prenuptial agreement. Emily obtained it from Daniel without raising any suspicion at all, telling him simply that the farmer liked to look over paperwork out of old habit, and that it made her feel better to have someone she trusted glance at it first. Daniel handed it over without a second thought, entirely unaware of what he was actually carrying into my hands. The document itself ran 53 pages of dense, deliberately exhausting legal language, the kind engineered so that a tired reader gives up around page 20 and simply signs where indicated. Buried on page 31, tucked into a subsection blandly labeled Family Financial Contingencies, sat exactly the clause Patricia and I had predicted, vague enough to look like unremarkable boilerplate to an untrained eye, specific enough to hand Charles Weatherby's firm a clean legal pathway directly to Emily's trust the moment she said, I do. I had my evidence. Now I needed my moment. I asked Emily to arrange one final family dinner before the wedding, just some paperwork to review together, I told her, and she trusted me enough, even now, not to push for more than that. We gathered at the Whitfield estate in Connecticut on a Thursday evening in late autumn, the kind of evening where the light goes gold and then gray all at once. Gerald poured wine with his usual practiced warmth, entirely convinced I remained exactly what I had always appeared to be. Marlene made pleasant small talk about centerpiece arrangements for the wedding, still 8 months out. Daniel sat beside Emily, his hand resting over hers on the table. utterly, painfully oblivious to what was about to happen in his childhood dining room. "Rick, glad you made the drive. Long way from the farm for a Thursday. Not as far as you might think, Gerald. I actually wanted to go over this prenuptial agreement your family's lawyer drafted. If everyone has a few minutes." I set the document on the table. 53 pages, 3 sections marked with yellow tabs I had placed myself. 3 nights running, at my kitchen table with a cup of coffee and Susan's photo watching from the windowsill. "Rick, I really do appreciate you taking the time, but I promise you, this is standard legal language. Nothing you need to trouble yourself with." Page 31, Gerald. Section 4C, Family Financial Contingencies. Walk me through what that clause means. In your own words, please. I watched something flicker behind Gerald's eyes that I recognized instantly, the specific, unmistakable fear of a man who suddenly understands he is not looking at who he thought he was looking at. Marlene's polite smile froze mid-formation. Daniel glanced between his father and me, utterly confused, sensing weight in the room he could not yet name. It's boilerplate. Every prenuptial agreement contains language like that. You're not a lawyer, Rick. You wouldn't necessarily. I spent 22 years reading contracts exactly like this one for a living, Gerald. I sat on the federal bench for over 2 decades before I retired to grow tomatoes on that farm you've mentioned fondly at least a dozen times since we met. I have seen this precise language used exactly once before, in a case I personally presided over. A man attempting to use his son's fiancée's trust as informal collateral to cover a 9-figure shortfall in his own investment fund. That man is currently serving federal time for wire fraud. The room went quiet enough that I could hear the wine in the glasses settling. Dad, what is he talking about? Judge, you were Rick, is that even true? It's true, son, and I'm sorry you're learning it this way, at this table, on this night. But I need you to understand, clearly and completely, what your father was preparing to do, using the woman you love and her late mother's final gift to her as leverage. I laid it all out, methodically, the way I once laid out closing evidence for a federal jury, plainly, without embellishment, because truth of this weight has never needed decoration to land. The SEC inquiry, already months into an active investigation, the $11 million performance discrepancy Patricia had documented in exhaustive detail, the engineered timeline, rush the wedding forward, get the prenup signed while everyone's guard was down, access the trust as collateral before any public enforcement action could freeze Gerald's remaining assets. Gerald, you told me this was handled. You told me we were simply protecting the family's interests. That was the phrase you used, over and over. You told me I was going to pay it back. Once the fund recovered, once the new capital raise closed, I was going to put every dollar back before anyone even. That is precisely what every single man I ever sentenced told me, Gerald. Word for word. Every one of them believed it, right up until the moment I read their sentence into the record. Did you know? Daniel, please, look at me. Tell me you didn't know about this. I swear to you, Emily, on everything I have, I had no idea. I signed what they put in front of me because I trusted my father with this kind of paperwork the way I always have. I would never, ever let anyone touch your trust. Never. I believed him completely. 22 years spent learning to read a liar's face across a courtroom had left me with very little patience for performance, and Daniel Whitfield's face, in that moment, held nothing but genuine, gutting horror. You've been watching us this entire time, playing along the flannel, the farmer routine. You were building a case against my own family, in my own home. At my son's engagement dinner, I was protecting my daughter, Gerald, the same way I protected 2 decades of victims from men exactly like you. The difference this time is that it's personal, and I am no longer required to remain neutral about it. I gathered the document off the table, gave Emily's shoulder a single, steady squeeze, and walked out of that house without waiting to see whose composure broke first. I did not need to personally destroy Gerald Whitfield. I only needed to make certain the full truth reached the people already quietly circling him. 2 weeks after that dinner, I made one more phone call, this time, deliberately, on the record. I provided Patricia Nguyen's full forensic documentation, alongside my own sworn statement detailing exactly what I had personally overheard on that Connecticut terrace, to the SEC enforcement attorney Thomas Reyes had connected me with. I was not simply a witness carrying a personal grudge. I was a retired federal judge with direct, first-hand knowledge of an attempted fraud committed against my own daughter, supported by documented, verifiable evidence. The weeks that followed moved with the particular, grinding patience of real institutional justice. Nothing like the tidy pacing of television. Investigators requested additional records. Patricia's documentation was independently verified. My sworn statement was formally taken, notarized, filed. 3 months later, Gerald Whitfield was formally charged with securities fraud and wire fraud, layered on top of the SEC's existing civil enforcement action. Whitfield Capital Partners, a firm his own father had built 40 years earlier, was fully dissolved within the year. Marlene filed for divorce before the month was out. Whether from genuine outrage at what he'd been willing to sacrifice, or simple, practiced self-preservation, I genuinely could not say, and by that point, I had entirely stopped caring which it was. The prenuptial agreement, naturally, was shredded. Not metaphorically, Daniel actually put it through a paper shredder in his own apartment. A small, private act of fury, Emily told me about months later, with something close to pride in her voice. Emily's trust remained precisely what her mother had built it to be. Hers, protected, untouched by a single hand that did not belong to her. Daniel came to see me alone, about a week after everything first broke into the open. He looked, that day, roughly 10 years older than the confident young man who'd shaken my hand at that first Manhattan dinner. I keep running it back in my head, Rick, wondering if I should have seen it somehow. Wondering if not seeing it makes me as complicit as he was. No, son, trusting your father with paperwork isn't a crime, and it never will be. What actually matters is what a man does with the truth, once it's finally placed in front of him. You came here, alone, to face it directly. That tells me everything I ever needed to know about you. Daniel and Emily postponed their wedding by 8 months. Not, I want to be clear, because their love had cracked, but because they both needed real time to rebuild what trust even meant to them, on entirely their own terms, with no other family's fingerprints anywhere near it. They were married last spring, in a small, unpolished ceremony held right here on my farm, under the same wide oak tree where Daniel had first proposed beside the pond. I walked my daughter down a simple dirt path instead of any marble aisle, wildflowers instead of imported orchids, and it remains, without any competition whatsoever, the proudest walk of my entire life. People ask me sometimes, usually over coffee, usually with a certain careful curiosity, whether I regret playing just a farmer for as long as I did. I don't. Not for one single day of it. Gerald Whitfield underestimated me because I wore old boots to his dinner parties and talked about tomato blight instead of quarterly earnings. That underestimation is precisely what allowed me to watch, to wait, and to quietly assemble a case airtight enough that no lawyer his money could buy would ever talk his way around it. I spent 22 years of my professional life believing one simple, stubborn idea, that the truth, given enough patience and enough attention, always eventually finds its way into the light. I never stopped believing that the day I hung up my robe for the last time. I simply started proving it one tomato harvest, one quiet phone call, one careful Thursday evening dinner at a time. Susan built that trust in her final months, specifically to protect our daughter long after she herself was gone. I like to believe, in whatever way a man allows himself to believe things after losing the person he loved most, that she somehow already knew exactly who she was leaving behind, to make absolutely certain no one would ever touch it. They called me the farmer. They should have taken a moment to ask what a farmer does with people who try to poison his fields. If you believe some people never truly learn a lesson until they've lost absolutely everything, You already know exactly what to do below this video. If this story hit home, hit subscribe. Vengeful patriarch posts a brand new justice story just like this one every single week. And down in the comments, tell me honestly, would you have exposed Gerald right there at that dinner table the moment you overheard him, or would you have waited and built the case quietly the way I did?